Thank you, Ness. Good morning, everyone. My name's James Donnelly, and I'm the founder and CEO of the Castle Group, and welcome back to episode 9 of our webinar series, Combating COVID-19. And I would like to welcome back Donna Berger, shareholder at Becker Law Firm. Hello, Donna, welcome back.
Hi, James, good to be back.
So we took last week off, and we decided that the frequency based on what the changes are is a good one every other week. So we'll be back in 2 weeks from now, June 10th as well. I want to remind everybody, I could tell from the questions, we had a lot of new participants today. And so if you are interested in any of our past episodes, we have them all up on castlegroup.com. Just hit our COVID page, a banner. And similarly, if anything that we talk about today you'd like to get some copies of, then please email info@castlegroup.com. So any questions you have, frankly, that we don't get to. I also want to remind everybody, we always get a couple people who are having some technical challenges, and the usual fix is simply to log off and back on again. And I also want to remind everybody that Donna has been so generous with her time for the last couple of months, and her opinions are very good, but they're really hers for her today, and she's not giving any legal advice. And there's never been a time more important for you to seek counsel with your own association's attorney. But I think Donna's discussions are always great for framing the questions that you can ask your attorney.
Although, James, some of my clients are listening in, so hi, clients.
Except for the ones that are Donna's clients, then call her right away. Thank you for that reminder, Donna. So I want to keep the fun and interest of these webinars up. And one of the things we decided to do today, many of you have been asking us, how many people have their pools open, and how many are doing this, and how many are doing that. And so we're going to try something new this week. We're going to have live polling. So in a couple of minutes, I'm going to ask the audience a question, and you'll be able to answer it on your screen. And literally 30 seconds later, I can share the results of that with you. And so that's
I'm excited, James. I'm excited about that. We tested this yesterday, and it's kind of cool.
Yeah, it is very cool. The other thing that Don and I were thinking about, because some of you are relatively new viewers, and then a lot of you, just as a recap, Donna likes to give me long answers. So I asked her if she'd be open to doing a lightning round of things we've covered before. And so we're gonna do that as well today. And then as your questions come in, and I see they are coming in, a couple of reminders. One, we literally can't answer all the questions. And so what we try and do is kind of group the questions into more general. And so I've talked to some of our clients, Donna, and they're saying, I really want more regional, more local information. And so my answer to that is we're putting together at Castle some regional webinars, and we're even organizing our first Spanish-speaking only webinar, so we can reach deeper into our communities and give you more local knowledge. But apologies in advance if we don't get to your specific question at your specific property. So with that, quick update on what's going on in the world. We're up to 52,000 cases in Florida, 56,000 in Texas, and over a couple thousand deaths now in Florida, and 1,500 in Texas. These numbers are obviously still bad, but I can tell you we're definitely on the correct side of the curve, and we'll talk about it more, Donna. But as long as we stay diligent and follow some of the things we're going to talk about today, I think we can keep coming off the peak of that curve. In Florida, basically the governor's told us pretty much statewide now. Phase 1 is open, and that's including beaches and pools. Even Miami, I think the pools are opening next week. Not the gyms, I don't think, but also some opening on vacation rentals. So there's a lot more flexibility, Donna, in our regulation. But I'm going to pause for a moment. You always give us some great advice on regulations kind of being more the floor than the ceiling. Maybe just remind our listeners about that.
Yeah, and we've actually had, James, a glimmer of hope in terms of local government reacting to some of the confusion that's been out there over the last few weeks as these local orders started coming out in terms of reopening pools, amenities, and things like that. Broward County just came out with a new order, a revision that basically took into account that there was confusion in the community association arena, and basically said that if associations, their rules can be more stringent. They actually said that. And if an association does not feel it can manage a reopening a particular amenity, they're not required to do so. Now, look, that's the same advice that we've been giving to our clients across the board, James. But now this is the first time we've got a county that's actually acknowledging that association protocols can be more stringent. And that's what we've needed all along. And I know we're going to talk a little bit in a few minutes about how these orders have created some confusion. But I'm grateful that Broward County did clarify that, because as we've been saying, these orders are the floor or the minimum of what associations can do. By the way, the Florida Department of Health and the CDC have also released fairly comprehensive protocols regarding amenities and how to clean them, how to monitor them. And those are, I looked through them this morning. They go into a little more detail than a lot of these county orders. So you have to be looking at that as well. Certainly following DOH and CDC guidelines is a good idea.
Yeah, and in fact, Donna, we put up on our COVID page on casagroup.com some links to those references, and they're really, I think CDC has really gotten better and more granular through this pandemic. But if we're going to get some questions about cleaning frequency and cleaning protocols, we probably won't be answering them that closely today, but you can go to casagroup.com and click on the CDC guidelines for cleaning and disinfecting. I also wanted to mention, Donna, before I get too deep into the questions that are flowing in now, we have hurricane season starting on Monday, and a reminder to all of our listeners, you have to have your hurricane plan completed now. We already have Tropical Storm Bertha out there off the coast of Carolina. So it's the reason I'm re-emphasizing, most properties have hurricane plans, Donna, but there are some nuances of this having to deal with a hurricane while dealing with the pandemic. So any comments just before I leave hurricanes behind us, hopefully for a long time?
Yeah, hopefully for a long time is right. Look, we hope as we sit here that everybody listening has a hurricane plan in place, but now you're going to have to look at that plan in connection with your COVID-19 plan, which most of our clients have implemented across the board, and see where there's overlap. Remember those concentric circles that we made in school? See where there's overlap between your hurricane preparations and your COVID-19 issues. If you have hurricane shutters that need to be installed, or if you're in the process of swapping out your windows, but you've got active infections in your buildings, this can present a problem, because now we've got kind of a confluence between dealing with this pandemic and trying to get ready for hurricane season. But all the things we typically recommend, which is date stamping, photos and videos of your property before the storm comes. I've got some clients that still need to do repair work before hurricane season, and that's important, because you know what happens if you needed to undertake certain work and now a new storm comes. You're going to have a problem with your claim, because your insurance company is going to claim pre-existing damage, lack of maintenance. So get with your attorney and figure out how to implement both your hurricane plan while you're still cognizant of what you need to do until at least July 7th with your COVID-19 plan.
Thank you, Donna. That's very good advice. And for our listeners, we do have a message here from Zoom that there are some delays. So I haven't seen it in your comments, but Donna, your words in your picture weren't lining up there perfectly. But all that to say, Zoom is working on it, so we will continue. Donna, I want to get into the lightning round, but one of the things that you and I discussed was a framework that would help our boards in decision making. And one of my themes today is there's increasing pressure on our boards to open stuff up. And I want to give our listeners some tools that they can deal with the pressure that comes from the residents. But as a reminder, Donna mentioned the CDC guidelines. These are so fundamental, and any opening that would violate the ability to socially distance and all of the protocols of CDC would be reason not to open up your amenities. Secondly, obviously regulation. Donna talked about it being the floor, not the ceiling, but you certainly don't want to do anything that's not already authorized by regulation. And then you have to think about your physical plant. A lot of our communities, they just can't open because the physical plant doesn't allow it. And then in addition, staffing. And I already see some questions coming through about if I don't have staff, can I open? And we'll talk about that in a minute, but for the most part, not. And then finally, the communications with your residents and your community, you cannot over communicate. So this is a framework, and we have that available for anyone that would like it in more detail than I just covered it. But if you consistently employ this framework, you have a basis to make these decisions and defend them to your residents.
But certainly a critical component of that, James, is a legal opinion. If your board has been making all these decisions about protocols, how to establish them, how to enforce them, when to relax them, loosen them up a little bit, you have to, your attorney, your association counsel is an integral part of that conversation. Remember, we've talked about the business judgment rule. Courts, Florida courts will give wide deference to the decisions your board makes, particularly now when you're trying to operate in the midst of an ongoing pandemic. But you have to pull your attorney into that and say, are we getting this right? Is there anything we've missed? And I have to tell you, I'm not surprised, but I'm so happy that so many clients are doing just that. And also, James, I found a lot of clients, might be because they're mine, because they know how I feel about this, but they've really resisted that pressure. They've said, we're going to do the right thing here. And they're opening up, and they're opening up in a consistent and a deliberate and a reasonable manner.
Yeah, and in addition to the legal approval, make sure boards that you bless your plan at a board meeting, and we're going to talk about meetings in a second. Donna, I think we should ask our first poll question. What do you think? Sure,
let's do it.
All right, our first poll question is if your community pool is open. So Ness, let's put that up there, please. And we'd ask everyone in the next 30 seconds to reply.
Oh, James, it says we can't vote.
You're not allowed to vote, Don. Okay, well, those results are being tallied. Don, I want to start our lightning round. Should boards be holding their regular and special meetings, yes or no?
First, before I say that, I'm going to say the first day of law school, they teach us to not answer questions, yes or no. So I don't know how you hoodwinked me into this, but okay. Should they be holding meetings? Yes.
Collections, should they be following their normal collection policies, yes or no?
Yes.
Out-of-state quarantine, is it still applicable or not?
Yes, still applicable.
We had a question come in, and I'm just going to jump in. See, you're supposed to be the quick answer now. I'm slowing you down, but there was a question posted, Donna. The governor in Florida's order was very specific about regions that you have to quarantine from. The question that came in was, what if you have someone coming in from a hotspot not enlisted in the executive order? How would you respond to that question?
Now remember, the association's protocols can be more stringent. So my recommendation would be have as part of your association COVID-19 plan that if anybody comes to Florida from anywhere, they're going to quarantine for 14 days. That's one option. Rather than looking to the governor's order or any of the local orders, I've looked at Governor, I can't tell you how many times I've read Governor DeSantis's orders, starting with the original 2052. It seems to me he has identified New York, New Jersey, Connecticut, but it also said arriving from out of state. So there's some room there to say, if it's somebody coming from, well, I know we've just suspended travel from Brazil, but if it's somebody coming from out of the country, we may be able to look to that order. But remember, those orders are not going to answer all your questions. So if you're concerned about people coming in from out of state, make that part of your own protocol as an association.
That's a great point. And that, so the answer to that question is yes, the governor's quarantine requirements remain, but you as an association, remember that's the floor, not the ceiling.
Right.
And we're going to talk, hopefully if we have time, Donna, you have such a good idea about documenting all the things our documents aren't doing for us right now so that we can amend them for events like this in the future. But we're not going to go there now. Ness, have we got our poll results yet? There we go. It's so we have 44% of polls,
wow.
41 no, and partially 15, which brings us to 59% open or partially open. And I know the castle companies were approximately 60%. So I know there's some regionality in that, but I thought
right.
Would enjoy seeing those statistics. Thank you everyone for participating.
So when your residents say every other pool is open, they probably don't have a full grasp of the picture.
Yeah, that's right. Okay, Don, a couple more lightning round, then we're going to get into the DBPR's announcement this past week, which I'm already getting some questions on. But waivers or no waivers? Did I already ask that one?
You didn't ask me that one, and that one I'm going to have to say generally no. They're disfavored by the courts. Some people like them. I personally believe they provide a false sense of security. I think they're virtually useless, particularly when it comes to trying to insulate the association from liability associated with a communicable disease. So overall, I'm going to say no on waivers. If it makes you feel good, go ahead and do it, but it's probably not going to provide the protection you hope it will.
Excellent. Someone's asking me, Ness, how many people responded to that survey? Will you text that to Kara or Hope, and I'll answer that question. Okay, going to finish the lightning round, Donna. Mask, yes or no?
Yes.
Violation.
But with the caveat that I've got some clients that are requiring masks in the gym, and if you're requiring people to wear facial coverings while they're engaged in cardio activity on a treadmill, I don't know that that's advisable. So again, some of these things are nuanced, but generally speaking, masks in the common areas, in multifamily buildings, yes. If you're an HOA with single family homes, no. I mean, that has nothing to do with the association. So I'm sorry, couldn't stick to your strict yes, no on that one.
I know. Well, it's a great point. And I'm going to try and sprinkle in some kind of practical management thoughts with Donna's legal ones. The bottom line is if you're within 6 feet of anyone, you should wear a mask, period. And as it relates to gyms, you shouldn't be within 6 feet of someone in a gym. And we're going to talk about some gym protocols in a minute, Donna. And another one that's come up is elevators. You absolutely have to wear masks in elevators, and a lot of our communities are limiting occupancy per elevator, usually 4 people. So I'm just trying to shoot out some ideas as we go through here.
But James, may I just pop in? For instance, I live in a homeowners association. I know we've got a lot of HOA boards listening right now. I look out the window, my neighbors are walking around without masks, and in our association, we don't care. That's not something that we feel is necessary in this particular community. If they want to leave their homes and they want to walk around and walk their dogs without a mask, that's fine. If you go down to the clubhouse, then you should put a mask on. So again, there's a lot of differences if you said from the outset in terms of your physical structure, your physical infrastructure.
And let's remind each other, Donna, to make distinctions between condo and HOA as we go through, and we also have a lot of adult communities 55 plus. The answer to the question, how many people answered, we had 225 people answer the poll question, and approximately 60 of those pools are open. Okay. Last week, Secretary Bashir issued Executive Order 6, ending emergency powers. And I've got a bunch of questions here, Donna, because a lot of the decisions our boards are making are based on the emergency powers, and yet the governor still has emergency powers currently in place until July 7th. I'm a board member. I don't know what to do. What do I do, Donna?
Well, let me start out by saying it's incredibly disappointing to me and our clients that there has not been consistent messaging across the board when it comes to local government and even state government in terms of what associations can and should be doing. We've got the governor who says we have a statewide state of emergency that's in place until July 7th. And it may be extended beyond that point, James, because right now our numbers in Florida are pretty static. They're not going up, thankfully, but they're really not going down. So we're pretty static right now. And after Memorial Day and the reopening, we'll see where we go from here. So we've got a statewide state of emergency till July 7th. Prior to the number 6 order a few weeks back, the DBPR, which, as you know, regulates associations in Florida, condos and cooperatives more so than HOAs, but they still have their hands, to a limited extent, involved with HOAs, issued Executive Order number 4. And in that order, they said, okay, boards, you've got those statutory emergency powers in 718, 719, and 720, which is condo, co-op, and HOA, do apply in a pandemic, but they didn't say all of them apply. So we were scratching our head back then as to why the DBPR issued that order, because most association attorneys were already interpreting the existing statutory powers to apply in this situation. Now the DBPR has come out with Executive Order number 6 and said, oh, by the way, these emergency powers end on June 1st. Not helpful at all, and certainly not consistent with the fact that when you look at the current emergency powers in 718, 719, and 720, they say that they stay in effect as long as the statewide state of emergency is in effect. We've got a conflict here. It's really anybody's guess why the DBPR would have done this, but some association attorneys have reached out to the DBPR, and now they've said that they're going to take a neutral position on whether or not these apply. None of this makes any sense, but long story short, work with your association attorney. I will tell you, my advice to my clients is that they most likely have the authority to continue to enforce stringent protocols to provide a standard of due care while operating in the midst of a pandemic.
You know, we're getting the same feedback and advice from other attorneys in the industry, Donna, and I think this is a super important point for our listeners. Maybe one of the biggest ones for this week is I would even say there's a consensus that the governor's order still provides associations with that power. And I'm only telling the listeners this, and that you have to get that from your own attorney, but some of the recommendations that we've been making, Donna, are based on emergency powers. So we need those emergency powers to make the decisions we're making at boards. And again, I'm going back to my theme of trying to take some of the pressure off the boards. And another way to do that is make sure you get legal support for your emergency powers.
Well, and for those associations who've been fortunate enough to rewrite their documents, when I do a document rewrite, I put emergency powers in the bylaws. So in some communities, this is a moot point because their documents themselves provide the association with those powers. And I know in a future show, we're going to talk about that, but this is why it's so important to amend your documents if you're capable of amending them, because rather than waiting around for government to help, and you know, I just wrote an article about this, the cavalry really isn't coming. Government's not always there to help, and sometimes they can do more harm than good with conflicting and confusing messages, as we've seen. You know, put it in your documents. Then we don't have to have this conversation.
Yeah, I like your term. The cavalry is not coming, and the metaphor really means we can't depend on on the state government to give us all the tools we need to manage our community effectively. By the way, someone was asking what DBPR is. The Department of Business and Professional Regulation, which oversees the administration of a lot of the laws surrounding condominiums and HOAs and co-ops, including the licensure of our managers. I think we should do another poll here to keep the excitement going here, Donna. So everybody, if you would please get the mouse out and answer, is your community clubhouse open? Or if you're in a condo, I guess that would be your common rooms, but trying to get a feeling for whether the clubhouses and the common rooms are open. Please answer that now. It should be up on your screen. Donna, while people are oh, yeah, I see where it says hosts and panelists can't vote. Really feel slighted here. I just wanted to address, Donna, or have you address the HEROES Act. This is the $3 trillion bill that was passed in the House and is sitting unaddressed by the Senate. And there were two discussion points about this. One was there was an argument in the bill that the way it addressed consumer debts may affect our ability to collect maintenance fees. Let me stop at that one. I know it's not law, but it would be a concern for our associations if it did pass. And I can tell you, I've personally written Governor Scott and Governor Rubio in Florida and Cruz and Cornyn in Texas to ask them to address this if and when a bill gets to the Senate. But what are your comments and thoughts about the intent of the HEROES Act as it relates to collections?
Yeah, it would have been devastating for associations. Basically, the way it was written and it passed the House was that associations would not have been able to collect maintenance fees and regular or special assessments for 4 months after the state of emergency, the national state of emergency passed. As you know, we're still under a national state of emergency, and we don't know how long that's going to continue. That could continue for months. So conceivably, if the HEROES Act had passed, it would have been devastating to associations. My other hat I wear is I'm executive director of our call group at Becker, the Community Association Leadership Lobby. We've reached out, we got an alert out to all our people to contact Senator Scott and Senator Rubio and let them know the bill was dead on arrival in the Senate, but our fear, if this pandemic continues to wage on over the coming months, some portions, there will very likely be another stimulus act, James, and we have to make sure that the consumer debt portion that's in there. I had a client say to me, I went through the bill. By the way, it's 1,800 pages, James, this bill. He said, I can't find any mention of HOAs or condos. You won't find that in there, but what you will find are the words you can't collect consumer debt, and the courts have held that maintenance fees are considered consumer debt if it's somebody's primary or secondary residence, okay? And that pretty much constitutes the majority of households in Florida in community associations. It's typically either their primary or their secondary residence. May not be a consumer debt if it's an investment-owned unit. But long story short, HEROES Act would have been devastating to associations. So for everyone listening, I would still urge you to contact your United States senators and tell them that any portion of this bill that gets revived, contact your US reps too, cannot include maintenance fees for associations.
And Donna is a representative of several groups, interest groups, advocacy groups for our industry, as am I, and they're all aware and are monitoring this situation. Don, a couple of quickies. I just see them coming through here. Firstly, people are asking for past episodes, casagroup.com, you can see them. There's a question, I think we may not have been clear enough on emergency powers. Our suggestion is that emergency powers still exist in the state of Florida, based on the governor's order. And so you're only, period, check with your attorney.
Well, I do want to say one thing. There is an argument to be made now that DBPR has mucked up the waters. Somebody could say, well, after June 1st, DBPR said these emergency powers are no longer in effect. We can't say that you're not going to have an argument. You know, my advice had been, look, if somebody has a problem with stringent protocol and they bring that issue to the division for an arbitration, you may not win at the division level. The division, because they're the ones who issued this order, may say, no, you didn't have those emergency powers. If you went to court for a trial de novo, I feel pretty confident the association would be found within the business judgment rule to exercise reasonable due care. So we set ourselves up for a little conflict. But now that the division has once again said, well, we're going to take a neutral position, who knows? I mean, we've seen this back and forth with the division. Do you remember term limits, James? You know how many times they circled back and forth on whether or not it was retroactive or prospective? We had some confusion there too. So I can't say definitively that you couldn't get pushback from the division on whether or not emergency powers applies. This is a very complicated issue now, which frankly should not have been complicated. It's disappointing that this happened.
Right, and I just want to make sure my listeners, obviously, we can't give a definitive legal opinion on it, but I think the business judgment rule will jump in here at some point. Because I have a question up here right now, Donna. Well, on June 1, do I have to open my gyms? And
No.
That's a bad idea. I'm giving you non-legal advice. I would look for every support you can at your association, obviously from your attorney, to get an opinion for your association that your emergency powers are effective after June 1. Because it would be a disaster if we all of a sudden opened everything up without restrictions.
So let me just say this really quickly to put a pin in it. Board's source of authority and powers do not solely depend on emergency powers. Boards have other powers in their documents. You have other powers under the statutes. You need to look, some documents are very broad in terms of what associations can do. You got a good association attorney, will most likely find you the authority you need to provide the standard of due care you need to provide in the midst of a pandemic. So emergency powers are great. They're the cherry on top, but they're not the only thing you need. I'm sure there's other sources of authority we can look to and that I've looked to for my clients that will get you where you need to go.
Okay, I think that's a good way to put a pin in that. I want to get the results out, Ness, of our second poll on clubhouses and common elements, and the answers are wow.
Yeah.
Yes, 6%, no, 88%, partially 6%, and the answer is that's 233 answers. So that's not surprising, actually. We've talked about this all along, Donna. It's way easier to social distance outside than inside, and there's way less touch points.
Yeah.
But there's the data. So that's exciting that we're getting this out to our listeners, Donna. Okay, the second part of the HEROES Act that wasn't addressed, and I know Senator McConnell wants, is the whole concept of limitation on liability. And we received about 300 questions this week, Donna, in advance of this webinar. How do we legislate possibly liability? And so I think I'm just going to put it in a bucket of risk mitigation. But do you think that there's any likelihood at the state or federal level that we'll get any limits on liability from our lawmakers? Let's start with that.
Yeah, I mean, let me put it this way. I always get these questions, particularly with my work through call, and it's the old TOBO. There ought to be a law. Legislation is great, but that's the most difficult path to pursue. Would we possibly get federal legislation limiting liability? Perhaps. Is it likely that associations would not be taken into account with that federal legislation? I would say almost undoubtedly. We see across the board that the federal government, whether it's FEMA and debris removal, whether it's flood insurance, there's just very little recognition on the federal level and sometimes even at the state level of how associations operate, which is so mind-boggling to me, James, given the significant percentage of Americans living in mandatory community associations. The fact that our legislators still don't take them into account when they're passing these kinds of laws, it's mind-boggling. And it's kind of been our work. I know you work at all these organizations too, to educate our public policy makers that, hey, there are millions and millions of Americans living in these communities. When you're drafting legislation, please take them into account. So on a federal level, yeah, probably somebody else will get helped, but not our associations. On the state level, I have more optimism in terms of being able to amend the statutory emergency powers in 718, 719, and 720 to expand the limitation on liability. As you know, James, right now, there is certain limitation on liability for boards in the aftermath of a hurricane. So if a board says you got to evacuate and people don't evacuate, right now the statutes say the board's not going to be liable for somebody who doesn't follow the board's orders. We could easily expand that language to include actions that boards take in connection with trying to operate in the midst of a contagion or a pandemic. But then lastly, I would say this gets us back again to amending your documents. That's where we're at the most local level. I hope every association, when the dust kind of clears, reaches out to association attorneys. I'm already working with clients. I'm going to put that in my rewrites. From this point forward, when I rewrite or amend documents, there's going to be a limitation on liability to give boards more flexibility. And hopefully your members will see the wisdom in giving the authority to your boards to be able to be more nimble in the midst of these kind of crises.
Okay, well, I think that as it relates to risk mitigation, we've kind of talked about that all the way along in terms of making good decisions, having crossing your T's and dotting your I's with respect to the decisions you make, communicating well, insurance we talked about. All of this is really about, I want to talk about the board, the pressure on the board. And you used an example the other day in terms of a board's thinking of what will they do, was you pretended there was a lawsuit and you were pretended that me, the board member, was being deposed. And you ran through like an example of some questions. And it was very clarifying to me, Donna. It became obvious what the answer was. I'm not sure whether you have an example or not, but just walk through like you did with me for our listeners. Because I think, again, we're trying to put tools in the tool belt of our board so they can make decisions and feel good about them. But that was a really good test in my mind for good decision, bad decision.
Sure. So let's take the example of Mrs. Jones, and she wants to do a powder room renovation right now as we sit and speak here on May 27th. We've got a state of emergency until July 7th. Mrs. Jones sees that the board has now allowed new tenants to move in. So we've relaxed our guidelines when it comes to tenant move-in. Of course, we've implemented protocols saying that the tenant has to pay for cleaning costs, and we're limiting the size of the moving crew. But Mrs. Jones sees this as the revised protocols goes out and says, well, I want to do you haven't allowed me to do my renovation on my guest bathroom, and I want to do it. And you're opening this up, open this up. So I say to clients, look, you have to be able to answer questions if you open it up. And I think we talked last time we met, James, about that lawsuit in Palm Beach County where the 92-year-old resident sued the board because they did open up, they did relax protocols regarding unit renovations. And the crux of his complaint was, you're putting me at risk by allowing an aesthetic renovation to continue in the midst of a statewide emergency. My point to you, and the point I make to clients, is picture the interrogatories, and this applies across the board. And here's the questions you're going to get from plaintiff's counsel. What amenities were opened? When were they opened? And they could do the math. You opened on May 27th. We had a statewide state of emergency to July 7th. How many staff members were appointed to monitor? How often did you clean? Was the staff member there every hour that the amenity was opened? They're going to ask all these questions, but the overarching question, when you said when you're on the stand or you're deposed, what was your rationale for allowing Mrs. Jones to continue with her powder bath renovation? And it can't be she's a pain in our butt and we didn't want to keep hearing about it. That cannot be your rationale when you're being deposed. You have to be able to come up with a plausible reason, which is, we managed it, perhaps it was a limited crew, it was a 2-day job. But if you're looking at aesthetic renovations that are going to go on for weeks or months, that's going to be a harder case to make, and you just have to be prepared. I think a lot of people are making these decisions not thinking of how they would explain this in a deposition or on the stand.
Right, and thanks for sharing that. And I just wanted for our board members to think about that. You could almost, when you have to make the decision, pretend you're being sued and how you would defend it, which is really what you were saying there. I think this is a good time. You just mentioned as an example, letting contractors in, and I know we have some questions about that. But I thought I would ask our third poll question, but Ness, it's not the third in order. We have, oh no, it is, the third one. Are you still restricting guests and other non-essential visitors? Let's get a poll out there, Donna, to see what our communities are doing.
I'm really interested in this one.
Yeah. And Donna, while there was a question that came in, what if a board is abusing their emergency powers? What's the recourse for a owner if they feel that their board has gone too far?
Well, listen, board decisions need to be reasonable. So if they are being completely unreasonable, let's take the example of a homeowners association. You've got single family detached homes. Is it really reasonable for an association in that instance to say, you can't do any renovations right now? Really, it's not going to impact. There's no common areas to speak of. That may very well be seen as being unreasonable. But then you have to look at owner in a single family homeowners association. They're not going to be able to take that dispute to the division to mediate. They're going to have to go to court. So again, it's going to depend on whether or not that owner has the resources and the tenacity to pursue the owner. Look, some owners have hired counsel and they have reached out. I will tell you, in the multifamily building realm, most of those attorneys, when we've explained what the risks are, have actually backed away. Again, in a multifamily building where you've got shared common areas, where you've got a vulnerable demographic, it's going to be much harder for an owner to claim that their convenience takes priority over public health and safety. Okay.
I want to, by the way, some people are asking me what bill number the HEROES Act is. I don't know the answer to that, but you could Google it. Do we have the results of our poll for, what did I ask? Restricting guests.
Guests, yeah.
Here we go. Wow. So we had 227 responses, and 56% are now allowing guests and are restricting non-essential guests, and 44% are allowing them. Again, we don't have regional numbers here for this, Donna, so I bet that's skewed a bit from north to south in our state.
Look, I would just caution, James, that the people who are not restricting guests, make sure that you're in compliance with your county order. Because remember, that's the minimum of what you have to be doing. Remember those interrogatories? If you are allowing guests in your local county order, like Broward County, for instance, clearly says that no guest usage of the pool. So if you're allowing guests to use your pool and you're in Broward County, you are operating below the floor. And that's a problem.
You bring up a really good point there. Like, when I think access, I think first owner versus guest. Forget about contractor and realtor and whatnot. I still believe that it's early to be allowing guests into community, certainly in the southern half of Florida. There's just no reason to expose your owners to basically double the number of people. With contractors, I found it interesting, and obviously Castle headquarters is in Broward, so I get the most press on that. They've specifically allowed realtors and contractors into buildings and communities. So that increases the pressure on our boards to allow that. but there would be an example in Broward where they're starting to allow that. What are your thoughts on that statewide?
Well, look, I also think that there's a misperception that it's always the threat coming from the outside in. If you're allowing visitors and guests, and let's say you're allowing realtors to show properties, I haven't heard of anybody who's allowing open houses right now, thankfully. You don't need to have an open house in the midst of a pandemic, but certainly appointments, okay, if you can reasonably manage that. But you may need to revisit that as soon as you have a confirmed infection in your building. Because if you allow guests to come and you've got a confirmed infection and you don't advise those guests, you may have a problem. You know, you may have a guest who later gets sick and says, you know what, was there a problem in that building that I visited? And then they trace it back to your building. So this is where you really do need to monitor this on a weekly basis to see what works and what's not going to work.
Well, Donna, the other thing I put under my board pressure topic was the risk of us moving too quickly is that infections spike, and then we have to reclose our amenities. And to me, that's the worst. I mean, we've tried to manage expectations, people's expectations, our residents' expectations through this whole crisis, and to have to go backwards. And I think there's another tool in the tool belt of our boards to say, look, if we move too fast, we may have to move backwards. You have a comment on that?
Listen, I'm a big fan of very phased reopening. For communities that flipped a switch and reopened the pool as soon as the order said the pools could be open, and they were back on that 7-day, 10-hour-a-day schedule, I think that's a huge mistake. Most of us have had kids. Have you ever given your kid one curfew and then you had to cut it back? It's very difficult to go backwards. So hopefully, you're starting out slow, 2 days a week, 3 days a week, 5 hours a day, where you can manage it. And then you make sure that you can continue to manage it. And as you see that you can add as you go. But you're correct. It's very difficult to peel it back and then to have to reclose again. And that may happen if we start seeing spikes.
I want to continue to make our distinctions between condominiums and HOAs. Obviously, contractor access and realtor access to a single family home is a different story. I believe most of the communities in that situation are allowing that now. Let's get a little more granular. We have about 10 minutes left. Actually, on the point of access, it really brings up the question of masks or facial coverings. And we have a question on this. And before I forget, Donna, to our listeners, I see a couple questions that you're putting through here that I think would be great poll questions for next episodes. So I welcome listeners. If you have a proposed polling question, you want to get some information on what the rest of the communities are doing, just submit it either to info@castlegroup.com, or you're welcome to put it on here. But our poll question, yes, I'm going to jump to number 5. Is your community requiring masks or facial covering in common areas? There we go. It's up.
James, let me just jump in one last thing on visitor access, because this has been such a hot topic with our clients. If you've now relaxed your restrictions and you're loosening up, you're allowing some contractors, some construction projects to take place in the community inside the units. Hopefully they are not lengthy projects that require large crews or that are going to create a nuisance. But let's say you've opened that up. Let's say you're now allowing realtors to have showings in the building by appointment, and you're requiring these people to wear facial coverings and protective gear. If you find out that you've got realtors or contractors who are not following these rules, speak to association counsel, because you may want to, you would take a very hardline approach and let these folks know that if you continue to violate our COVID-19 protocols, you may no longer be welcome in this community to continue doing business right now.
I take it a step further. We obviously manage a lot of communities, and if our contractors aren't wearing masks, they don't get in the building. We'll deny them access. Okay, do we have an answer? Couple bit more minutes to that. Okay, Donna, I want to jump in. We're getting questions specifically about pools and clubhouses and gyms and tennis, and I don't want to run out of time. Let me frame it, because I think I can answer most of the questions just by framing it. Number one, obviously, starting June 1, any pool in Florida is allowed to be open. And some of the best practices we're seeing is, number one, it doesn't have to be open completely back to full hours, because it does have a staffing requirement, a monitoring requirement. Two, you can very much structure your pool area. Obviously, I don't know all your pool areas, but most of them are open enough. You can literally either don't put furniture and have people bring their own, or set it up for social distancing. And the third thing is, I saw a question there, are we starting to allow activities into like pool activities? And the answer is yes. In many communities, as long as the pool's big enough to social distance, they're actually starting some of their classes. But what are some of your concerns about pool openings?
Well, first of all, if you have an active infection or an ongoing infection or an ongoing quarantine in your community, I would not recommend opening the pool until after that infection or quarantine is cleared. I just wouldn't. Again, I get back to that set of interrogatories, which is, did you have an active infection or a quarantine during the time the amenity was opened? I don't see the need for that. I think it puts you potentially at risk. Assuming your community does not have an active infection or a quarantine situation, because remember, listen, we're not condo cops or HOA cops. You're not going to, if the people show up from New York, or even they manage to get here from Brazil or wherever, and you've got the pool open and they're going to the pool, are you going to tackle them before they get to the pool? You're not. And now you've got a potential issue for that day or the day, or until the sheriff gets out there. And even then the sheriff may not do anything. So it's a completely different deliberative process, James, if you have an ongoing infection or a quarantine situation. If you don't have either of those things, then it boils down to, can we manage this? And you touched on this early about having staff. In some communities, we know Palm Beach officials have clarified that you can use volunteers to monitor the pool. You could use owner volunteers, or you could use board members. The only thing I would caution you two things. One, how agreeable are the volunteers you're going to appoint to be monitoring? Because you're sitting there and it's already an emotionally fraught situation. You're going to have somebody who's potentially telling people what they can and can't do, and we all know how much people like to be told what to do. Secondly, you may not have insurance coverage if that volunteer is hurt in some way in that capacity. That's why, in my opinion, using paid staff for that function is preferable.
I want your distinction of what you have an infection in the building. I think I can't emphasize enough, Donna. It changes the game.
Yes.
We had our first teammate with a positive infection. We have 1,800 teammates, and I've been knocking on wood for 2 months now. But it really, even more than a resident who can self-isolate, the impact of a teammate having an infection in a building is fairly dramatic, obviously on the person on the team, and then, of course, the whole community. And you've got to do a lot of tracing and tracking. So everything Don and I have talked about so far today, I think it changes significantly if you have an infection. I want to get the polls up, Ness, for the facial covering question before I forget. Okay, so is your community requiring facial coverings? We have 199 answers, 61% yes, 39% no, and I know that is biased by HOAs. It's generally in the condominiums, it's almost all yes. So we may have to tighten that question up next week, Donna. I also had a question come through here. We've talked about get advice from your attorney, get advice from your attorney. And then we talked about, yes, you should have meetings. Does it make any sense for our boards to have a closed meeting with their attorney? I mean, sometimes it's best to kind of talk through the parameters of how we're going to make our decision in closed meeting before we have our open meeting.
Yeah. Great question. And that was an issue before this pandemic. Listen, you can close your meeting if you're meeting with legal counsel to discuss proposed or pending litigation. Okay, that does not mean just because you have me on the line at the Zoom meeting, that we can start talking about projects and the budget and everything else. So typically, if it's just revising the COVID-19 protocols, even if I'm there, that's going to be an open meeting. That's not proposed or pending litigation. That was not the purpose of the statute allowing you to close a meeting. You can't just have your attorney there as a fixture so you can close it. I know that these meetings can sometimes be a little distasteful, although I will tell you, we've gotten such great feedback, greater participation with the virtual meetings, and people behaving a lot better. That may be a result of being able to use the mute button. I don't know. And one of the things we'll be looking to the legislature next session is to see whether or not these virtual meetings could become a permanent option, because I think they're actually incredibly useful. I think boards are more comfortable doing it that way. I think members may even be more comfortable doing it that way.
Yeah, I'm in 100% agreement. Okay, I don't want to run out of time, which we always do. We haven't talked about gyms, and gyms are starting to open. I can tell you in our communities, it's either no or highly restricted, but I'll give you a couple of examples. You have to pre-register, you have to book a slot, you have to check in, at the front desk, you have to be escorted to the gym, you have to wear a mask there, you have to have the equipment cleaned between use, and you mentioned not having to wear a mask. I agree with that just for health reasons. Hard to work out with a mask on, but you really have to think about the spacing of the equipment. Any advice for our listeners as they contemplate opening up their gyms?
Well, this is really just more practical. I'd be interested to see if your gym usage resumes or if it's diminished as a result of this pandemic. Look, before this, I worked out at my gym constantly. Now that I bought all the equipment I needed to use at home, I'm so comfortable with my online fitness classes now, and I'm not exactly rushing to get back to a confined space where people are sweating all over equipment. So we may find, James, that the capacity, that the usage has gone down and will continue to be minimal, even after it's opened up. I think you do need, again, even though the orders don't say this, I think the most prudent course of action is to have an employee present in the gym while it's being used to make sure social distancing is being enforced and cleaning is being performed. And that is after every use. That is the most prudent course of action. If you could answer that question on that interrogatory, yes, we had a staff member every time somebody used the gym, we made sure that social distancing was enforced and we cleaned up after it. That's bulletproof. Otherwise, it's not requiring that, but again, you can insert more stringent protocols as a board.
I think as we run out of time here, there's several questions about, well, what can we open, and can we use parking lots? Can we use the beach if it's open and whatnot? And I think again here, this is really, the answer legally, I'm sure is you can. I think any common element that you can open safely with social distancing and all the appropriate cleaning and safety protocols, our residents are dying to get some activity. So I would say yes, obviously subject to your legal advice, but that includes tennis. The USTA's got out some good guidelines. Pickleball, we get questions, can we play doubles? The theory is no, you can't socially distance.
And look, are your members willing to pay a special assessment to hire additional staff to allow you to open these amenities right now before July 7th? If the answer is yes, we as members, we will pay to make sure we open this now, but we open it safely, then go ahead. If you can manage it and you've got the proper staff to manage it and clean and monitor social distancing, the problem becomes, James, the residents want it open, but they don't want to pay anything to have it opened. And they don't necessarily want to be told how to act while they're enjoying the reopened amenities. That's where we've got the inherent tension.
Okay, so everybody, thank you for attending again this week. And also give us some feedback when you get the survey about the polling. I was very interested in the results. Yeah. Send in suggested questions. I think, Don, if there was a couple of takeaways for today, number one, it's actually harder, in my opinion, to open amenities than to close them because you have to be so nuanced. And really, we're just thinking of common sense and good business judgment and getting legal advice. And then the second big one, unfortunately, DBPR came out with this executive order that's really put confusion about emergency orders. And I almost think every one of our listeners is going to have to, unfortunately, even though it costs some money, they're going to have to seek out some legal advice. I don't see any choice but to keep these limitations in order, or we're going to have a disaster on our hands. But neither do I want them to leave this meeting without knowing they should seek legal advice on this. So I am going to leave for you, Donna, as always, the final word. Any last words of wisdom for our listeners before we sign off?
I would just say we're going to get there. Okay, we're moving forward. We're moving forward deliberately, consciously. And you're right about the reopening, because it is a conscious choice now. You know that the closing was, we were following the mandates that these things need to be closed. It's a lot more weight on the shoulders of volunteer boards. I would like to thank the boards that are listening, the board members that are listening. None of you signed up to serve on your board in the midst of a pandemic. It's a tremendous amount of responsibility on your shoulders. So thank you. I served on my own homeowners association board for 2 years, so I know what it feels like to sit in that seat, although not in this situation. We'll get there. And as for the confusing order, you're right. The result of that is that the DBPR's order has virtually guaranteed that my phone is going to ring off the hook.
It was good. It was good for the legal profession. I'd like to add my thank you for the leadership of our board members, and really Donna and my outcome here. I know it's probably frustrating for you listening, because we're not giving you specifically in your circumstance what to do, but what we are trying to do is give you some tools to the tool belt so that you can make better decisions and perhaps ask better questions to your attorney. So with that, I thank you again for dialing in here and for your leadership, and we look forward to talking to you in 2 weeks on June 10th. June 10th. There we go. Thanks, Donna. Thanks, everybody.
Thanks,
Have a great
James.
week.
Thanks, everyone.